This courtroom exchange starts like many others, but quickly turns into a tense battle over responsibility, credibility, and one critical mistake: arguing with the judge after a decision has already been made. At the center of it all is a defendant trying to explain missed tests, medical conditions, and what he believes is a flawed process. But the judge? He's not having it. As the violations stack up and excuses start piling in, things escalate fast. The real question is, was this a misunderstanding, or a complete breakdown in accountability? Stay with us, because what happens next is a masterclass in how not to handle yourself in court.
You're not upsetting me, but I'm not going to allow people to argue with me after I've made my decision. You see that guy on the wall right now? Look at that guy. That was my father. You know what he told me when I graduated law school? Don't argue with the judge after they've made their decision. There were 3 things. That was one of them. I didn't then, and I'm not going to let people do it now.
Told him he would get paid the test, most likely today, that he would come back clean. He has maintained his sobriety. Judge, he had suffered an injury, his mobility's been inhibited, and he also did, on a positive note, start a new business, a tree removal service. And it was an arduous period of time when he was trying to balance his work and the court responsibilities. He understands court has to come first. I'd ask the judge that any sort of admonishment or sentencing be delayed to at least demonstrate that my client is remaining sober, clean, and absent drugs and alcohol.
Anything you would like to say?
Right from the start, the judge sets a firm boundary, and this is a huge moment. In court, once a judge has made a ruling, continuing to argue can actually hurt your case more than help it. The judge even references personal advice from his father, reinforcing how seriously he takes courtroom decorum. This isn't just about authority, it's about maintaining order and respect in legal proceedings. But here's the key question. Do you think the defendant realizes how much damage continued pushback can cause at this point?
No, that's correct, John. I've had some difficulties here with, my partner is in the hospital as we speak. I had to go with some independent contractors, of which 2 of them so didn't have a driver's license. So I was doing driving and trying to keep trees from falling into houses. I mean, I had some emergencies going on, and I just had a bad time.
Second.
Clean, and I want to get back on the program. I finished ILP. I'm doing OP now. I'm doing my meetings. Everything that is.
I told you from the beginning, if you didn't test, I was going to assume it was a positive test.
Now we're hearing the defense try to shift the narrative, bringing up injuries, work responsibilities, and even a new business. These are attempts to show the defendant is trying to improve his life, which can sometimes influence sentencing. But here's the problem. When you're under court supervision, especially in sobriety programs, compliance isn't optional, it's mandatory. Missing tests isn't just a small mistake. Legally, it's often treated the same as a failed test. So while the story sounds sympathetic, the court is focused on consistency and accountability.
You're losing this battle, man.
I really believe I can do it here.
Okay, well, but I can only give you so many chances. This is 8 violations now. Anything?
Your Honor, my concern is he missed a test in January. We talked about it, gave him a verbal warning. And then here in March, practically, half of March now, he's only shown for 1 accountable test. My concern is drug of choice. We're not talking about alcohol in this circumstance. It was drug of choice, cocaine. It's in and out of your system fairly quickly. It's been 1 to 3 days. We have essentially what I would do is back-to-back testing now, and over a holiday as far as, how you view St. Patrick's Day. But it was St. Patrick's Day weekend and St. Patrick's Day. He doesn't show for testing. He's delinquent in some areas of probation, nothing that kind of warranted a violation at this point, but he's due to still provide us with proof of a victim's impact panel completion. His community service was due March 1. He owes 56 hours. I've talked to him several times about it. I don't know where to go. I know he's in this program after having violated traditional probation as far as entering sobriety court a little bit late. So I have lots of concerns. I can understand one missed test based on all this issues with business and what have you, but to basically miss all tests but one in the first half of a month is pretty darn severe, pretty darn big.
You want to do the program?
I do.
I don't think you do.
I know it doesn't look like it, but I've had a lot of success.
I'm going to give you 7 days jail right now. You're going into custody for 7 days.
This is the turning point. The judge lays it out clearly. Missed tests equal assumed positives. That's standard in many probation and sobriety programs. And then comes the bombshell, 8 violations. At that point, the court's patience is almost gone. The judge even says, "You're losing this battle," which is about as direct as it gets. So ask yourself, at 8 violations, is this still about bad luck or a pattern the court can't ignore?
Next miss, next positive test, next screw up, I'm revoking you and we're done with you. You got me? You understand?
Yes.
7 days jail forthwith. I didn't think you were going to make it.
And I do have to ask, is it possible to get a report date?
No. Why do you have to ask that?
Because I always ask you.
Do I give report dates? Usually I don't think so. But hey, I get it. It's
Excellent.
Mr. Bologna.
Good afternoon, Your Honor. Anthony Bologna, Benton City Judge.
So I'm not going to make an issue of it. Your motion was filed yesterday. You can respond verbally, Mr. Bologna, okay?
Appreciate that, Your Honor.
Okay, go ahead.
Thank you. So we received the motion yesterday afternoon. Our response would be that.
Well, wait, let him argue first.
All right, go for it.
Go ahead.
Let me go first?
Yeah.
Okay, my motion. All right, thank you, Judge. I think it's self-explanatory, the motion. I believe it's right on point respectfully. We want, the court rule says about the interest of justice prior to sentencing, about a motion, if the plea itself was not defective by the court or by the attorneys, which we're not challenging. We're saying the interest of justice is the standard by court rule. And that is, it's almost, I wish all my cases were so clear cut, at least in my opinion. And that is, if somebody is a diabetic, and the law and the science is crystal clear that taking a breathalyzer is just not accurate. In fact, the officers are informed on their sheets that if somebody's a diabetic, not to give blood. And also the statute, I don't have it right this second, but I could have it in a second, that it only is blood and urine is permitted, obtaining a reading for blood alcohol content when somebody has diabetes. And it's crystal clear my client has diabetes. We have all the medical records for that. I didn't, I want to say it's sealed. I didn't want to provide those to the court. He can swear to it. His doctor has a letter that says that he's a diabetic. In fact, the letter says that it can cause artificial highs, and not negatives, but positives, in taking any type of a breathalyzer reading. And that's why it's blood only. So, Your Honor, I don't fault the officers. Of course, they gave a breathalyzer. But in the interest of justice, this is a very important case for my client, like it would be for anyone. And he's a medical doctor, and licensing to that. And so, it was a 0.09 and a 0.10. And if it was artificially high, what was his real blood alcohol level? 0.02, 0.03, 0.04 maybe, and it's artificially high. So in the interest of justice, and Judge, I've been 40 years, but however long the court's been on the bench, I presume about 30, is that I've never brought a motion like this in this building. And so I truly believe that we have good cause in the interest of justice by the statute or by the court rule, that it would be not fair to set it aside prior to the sentencing and allow him to proceed to trial. In the event the judge was Your Honor was kind enough, for lack of a better word, to set it aside and set a trial. That would be a for sure trial date that would go. I don't expect it to be any more at all than a one-day trial. Thank you.
Mr. Bologna?
Thank you, Your Honor. Yes, I received the motion yesterday afternoon. I think it allowed me to respond orally. We were here, Your Honor, as we would call, spent quite a lot of time trying to resolve this matter. We came to what we thought was a good resolution ultimately in this case. The plea was taken. The officer was here on that date. That officer is no longer, that officer is no longer a Trenton officer, so we had a subpoena to get him in here. We were ready to proceed for trial on that date, and we thought we had a resolution reached. As far as the whole argument regarding diabetes, it's a fact issue. I believe the officer, likely being the officer that it was in this case, probably asked if you have any medical conditions prior to administering anything. All that said, Your Honor, will ultimately reach the court's discretion, but the city was prepared to go on trial, or to go to trial on the date that it was actually set. So that's our position on it.
Your Honor, let me just, excuse me, quick reply. And that is, my client was never advised against the attorney. Unfortunately, I don't think practice that area of the law, at least beyond pleas. That is very important, and it's instrumental and material in giving a breathalyzer that if you have diabetes, then the acetones, and I put a little bit more of scientific terms in the motion. Thank you, Your Honor.
Anything else, Mr. Bologna?
Okay.
Except as provided, this is under 6310B.
And there it is, the consequence. 7 days in jail right on the spot. This is what's known as a short-term custodial sanction, often used to correct behavior before things escalate further. But notice the warning. One more mistake and probation could be revoked entirely. That means significantly more jail time. The judge is essentially saying, this is your last chance. The question now is, will it actually change anything?
Withdrawal after acceptance but before sentencing. Accept is provided in subsection 3 after acceptance but before sentencing. A plea may be withdrawn on the defendant's motion or with the defendant's consent only in the interest of justice. It may not be withdrawn if withdrawal of the plea would substantially prejudice the prosecutor because of reliance on the plea. I don't know that it would substantially prejudice the prosecutor, but I can't find that this is in the interest of justice. As Mr. Bologna pointed out, there were lengthy discussions that occurred on the date of the trial. There were numerous pre-trials. I remembered when you said sidebar, Mr. Kolovis, when you were here for sentencing, that this was based upon the fact that, primarily, that this was based upon the fact that he was a diabetic.
Correct.
I had read the report, which I never do. I'd read the police report, which I never do before there's a conviction on it. I'd read it the date of the sentence, which I always do when I'm going to sentence somebody. And if you look at the report, it says, Pastor informed me he did not suffer from any injuries other than some back pain. He denied being a diabetic. He stated that he had no recent head injuries. He stated that his highest level of education obtained was a master's degree. He informed me he could understand everything that I was saying. So when your client is now advancing this argument, or you are, I suppose, on behalf of him, the police report clearly indicates that he told them that he was not diabetic. I'm sorry, I'm going to deny your motion.
Your Honor, just if I need to put a record, just make a record. And Your Honor, he did not say that. And it's on his listing of his medication. And there's a letter from his doctor talking about it.
Well, I don't know how they're supposed to be mind readers.
But even if they,
Listen.
nobody says they are. Nobody says they did anything wrong. I'm just
It
saying.
says he denied being a diabetic.
And that doesn't mean the results.
That means that they might have taken other steps. And this is a decision I'm not gonna reverse myself on. I've thought about this. the interest of justice do not require setting aside the plea. I will be happy to let you appeal this. I will sentence him. You can file your motion to stay any punitive measures pending the appeal. I'll be happy to do that for you.
You know, Judge, what if somebody is raped and they're serving 50 years in the DNA contact? The person said,
Mr. Glovis, I heard you. I made my decision.
doing my talking, all right.
Do you want to sentence now? You ready for sentencing?
Your Honor, I would ask this, may we be allowed to do an interlocutory appeal?
No,
immediately?
I'm going to sentence.
You want a sentence?
Yeah, you can take your appeal and you can do, I will stay whatever's punitive.
I appreciate that, Judge. I suppose, go ahead and,
Okay,
with sentencing.
all right. So have you had a chance to review the report with him? And are there any material additions, corrections, or deletions?
If I may have.
Sure.
No? Yeah, go ahead. I understand your prescription.
Listen, Mr. Pastor,
Yes.
you guys can take an appeal. I'm not trying to jam anybody here. You told the police, according to the report, you denied being a diabetic. I don't know what they're supposed to do. Now even the police officer is lying in a police report, which listen, I'm not going to listen to this anymore. I made my decision. Nobody has ever heard me say I'm always right. Not one person's ever heard me say that. I'm moving on. We're going to sentence. And then you can take your appeal. I have no issue with that.
Thank you, Judge.
All right, is everything in this report accurate?
Yes, Your Honor.
Any material
Nothing
additions?
you have to leave.
Okay. Anything you would like to say on his behalf?
Your client, my client is a medical doctor. Medical profession, and he runs several offices with his wife, who's a medical doctor. He denies, and I understand the plea of guilty to him, but given the other circumstances now that he relied upon, he denies that he was under the influence that day. Thank you, Your Honor. Nothing further.
Sir, anything that you would like to say before I sentence you?
I have prescribed that for me the best year and a half. Got all my prescription. Nobody has ever asked me. I do not recall the officer has asked me. I'm not diabetic or not.
Can I see your AA attendance?
The guy in the park.
Pardon?
He may have it in the car. Do you want him to go to the car?
Do you have him in the car? Have you been going twice a week?
Yes, I will. Here. I got it. Can I continue that we talked to?
May he go to his vehicle, Your Honor?
Sure.
3 minutes.
Sure.
Hey, do you want to run out there and go get it? I'll reach back. You'll pass.
I'll tell you what. Come on back up here. Let's just finish the sentence. You give them the probation afterward, okay?
Okay, got it.
All right. Anything else, Mr. Pastor?
No, I'm not sure if any of my medical letters was being presented properly. And that was one of my main concern because of the fasting, my ketone levels and anxiety, and I haven't prescribed 1,000 milligrams of metformin. I got my prescription history for the last 2 years. I just emailed it to Mr. Gross. I have prescribed for diabetic medications, but I take every single day because my weight went up to almost 200 pounds after the.
I know, but you're not going to argue with me about my decision.
That's not my intention. And I wish this would have came to resolution way sooner, and our previous council would have presented this facts as well too, which I'm just coming aware of it. Is not none of this was being really properly presented, and I'm very disappointed about that because that should have been presented properly in a timely fashion. That was not my intention whatsoever to take this far out of context. That was absolutely not my intention. It was not my intention. I asked him to present the facts properly a number of times, and it has not taken place.
I don't know I didn't see anything that your lawyer did wrong. You didn't see anything your lawyer did. Listen to me. I don't want to quarrel with you. You denied that you were a diabetic according to the police report. Now, if somebody tells somebody that they're not a diabetic, I don't know how they can raise the defense that, yes, he really is a diabetic. He was just kidding, and they should have taken different procedures. Now, I don't want to dispute this with you anymore. I've had this feeling the whole time, Mr. Pastor, that you don't think you did anything wrong. You really don't. And you had one 4 years ago. And you're only, what, 46? You get one in the next 50 years. That's a felony.
We're not getting one.
Well, I know, but nobody thought you'd probably be back the second time either.
It was not my intention.
Mr. Pastor, let me finish. It's my turn to talk.
That's-
If you have something else you want to tell me before I sentence you, I will be more than happy to listen, but I'm not going to go back and talk about your lawyer. I don't see what he did wrong. If you have something else you want to say that's going to cause me to be lenient, I'll be glad to listen, but please. Do you want to say anything else?
I'm not here to do anything plus. He's a such nice guy.
I don't want to talk about Mr. Zelnick.
Of course. I do not recall the officer asked me if I'm diabetic. I'm taking diabetic medication every single day. I listed on my medication sheet. I'm taking diabetic medications. I told it precisely every single day. I'm taking 1,000 milligrams. It's the highest milligram of metformin you can take. That's for type 2 diabetes. I mean, literally, I was getting heart disease. If I don't take that medication, I said show him my
Mr. Pastor.
He's past that right now, the judge.
And,
He's not gonna upset the judge.
and you can appeal this. I've never, like I just told your lawyer.
to offset you.
Now we shift into a more technical legal argument. This is about withdrawing a plea in the interest of justice. The defense is trying to argue that a medical condition, diabetes, could have affected the breathalyzer results. That's a real legal argument in some cases. But here's the issue. According to the police report, the defendant denied being diabetic at the time. And that contradiction is critical. Courts rely heavily on consistency, and when statements don't line up, it weakens credibility fast. So even if the argument has merit scientifically, legally, it's falling apart.
You're not upsetting me, but I'm not going to allow people to argue with me after I've made my decision. You see that guy on the wall right now? Look at that guy. That was my father. You know what he told me when I graduated law school? Don't argue with the judge after they've made their decision. There were 3 things. That was one of them. I didn't then, and I'm not going to let people do it now.
Not my intention, but
12 months probation. You're to submit the chemical testing, PBTs, and ETGs bi-week. You're to attend AA twice a week until in treatment. Once you get in outpatient treatment, you no longer have to go to AA or NA. You're also to attend the Victims Impact Panel. 5 days jail credit, 1 served 4. I'll let you serve those as follows. 2 days on the court work program. Those have to be completed by May the 1st. 2 days court work program. They'll schedule on those, and 2 days of community service by May the 1. Fines $300, costs $300, $75 victims' rights fee, $50 justice assessment. That is $7.25. Screening fees $60 for $785. Probation fees are $240 for $1,025. You have cost of recovery of $150 for $1,175 plus $70 in court work program fees. $1,245. You may be eligible for early discharge. If you complete all this in 6 months, you can apply. If you violate, your probation could be revoked. You could be incarcerated for up to 93 days with credit for 1 day served. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer. Now, what I'm going to do, Mr. Kolobus,
Yes.
I'm going to indicate on here, defendant need not report, and will you tell probation this, Amy, need not report. Well, look, I'm prepared if you appeal. You file a motion with me, and I'll make his fines due on May the 10th. But he's going to you can file a motion, and I will stay anything that's punitive. I'll stay which I don't consider to be AA outpatient or victims impact panel. I do consider it to be court work program, community service, or payment of fines.
Okay, thank you, Judge.
So you can file a motion when you appeal, and I'll be more than happy to stay anything that's punitive, but you gotta come in front of me and we'll figure everything out, okay?
Consider it, Judge, thank you.
And then he's gonna go meet still with probation, because I do need him to test. I want him to test bi-weekly, okay?
Yeah.
And I won't make your money due until May 10th, and if when we come back, I presume he's gonna file this real soon,
For next week.
I will be happy to extend the time period to pay and to indicate he doesn't have to do court work or community service until after the appeal is exhausted.
That's very kind of you, I appreciate your.
Okay. Thank you.
And patience.
Good luck, Mr. Pastore. Thank you.
In the end, this case comes down to 3 key factors: repeated violations, conflicting statements, and failure to follow court expectations. The judge ultimately denies the motion, proceeds with sentencing, and lays out strict probation terms, while still allowing the option to appeal. It's a clear example of how the legal system balances second chances with accountability. The defendant had opportunities, but consistency matters, and the court made that crystal clear. Now we want to hear from you. Do you think the judge was too harsh or completely justified? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.